Hi everyone, my name is Daniel Thorpe and I'm one of the junior barristers at Radcliffe Chambers. I'm joined by my colleague James Fagan, and together we will be talking to you about the new Chancery Guide. So on the 29th of July this year, a new edition of the guide was published, and that's the first complete rewrite since February 2016. What we're going to do is run through a whistle-stop tour of what we see as the new guide's 10 key points. So first, what is it? Well, essentially the guide is essential reading for litigators who practice within the Chancery Division of the Business and Property Courts. It contains practical instructions which build on and frankly often go into more detail than the civil procedure rules. It covers all stages of litigation, from the commencement of proceedings to listing, to the hearings themselves, and then on to appeals and enforcement. And it's intended to align the Chancery Division with how the Commercial Court and TCC operate.
Yeah, so the first sort of the things to note is that with the new guide, apart from practice notes which have been listed in the schedule of the Chancellor's practice note, which launched the guide, all other Chancery Division practice notes and directions have been revoked. So as if there's anything you've been using in the past or think you know, I would go and check that. And for those of you who operate outside of London, a new regional practice note for the Chancery lists in the Business and Property Courts in Liverpool, Manchester, Leeds and Newcastle has been promulgated.
Thanks, James. And then chapter 4, I should say, of the guide contains guidances to statements of case. And I think a particular note to practitioners is the guidance which is at paragraph 4.2, which I won't go through now, but sets out the fundamental principles which will apply to all statements of case in the Chancery Division. And at paragraph 4.4, the guide provides that no statement of case should generally exceed 25 pages, and it's only in exceptional circumstances that a statement of case should exceed 40 pages. Now, if you have a case which exceeds or should exceed that 40 page limit and is truly exceptional, the guide provides at paragraph 4.4 that a summary of that statement of case, which should be no more than 5 pages, must be filed at court, together with a brief note to explain why, in the party's view, that statement of case needs to be more than 40 pages long.
Turning to case management, chapter 6 covers this. There's an emphasis at paragraph 6.17 that the published Chancery forms draft directions are to be used or varied as appropriate in all cases. The courts will be expecting you to use those, therefore. Bundles are needed at all hearings, and the contents are strictly set out at paragraph 6.5. But also be aware that in paragraph 8.5, parties should consider a direction in all directions for a key documents bundle and narrative chronology for the purposes of assisting the trial judge. However, one thing to note is that paragraph 6.52, there's a direction that there should be a separate landscape bundle for cost budgets, precedent Rs, disclosure review documents, and any other landscape documents which are relevant to a case management hearing.
Thanks, James. And then chapter 7 goes on to cover disclosure. And following the happy news that the pilot scheme is set to become permanent, paragraph 7.3 to 7.25 provide helpful guidance to supplement practice direction 51U. And I think, again, without going into too much detail, of particular note should be paragraph 7.8, which deals with applications to dispense with the requirements of the scheme, and paragraph 7.12 as well, which contains what I think is helpful guidance on how to fill in the beloved disclosure review documents.
Turning to witness statements, as you might expect, this is a chapter 8, but it places heavy emphasis on trial witness statements under practice direction 57AC. A trial witness statement should refer to documents, if at all, only where it's necessary. And where it does so, the document should not be exhibited to the witness statement, but instead a reference number should be given, enabling it to be identified. And the same approach, the guide says, should be generally adopted for witness statements, for trial witness statements where practice direction 57AC does not apply, and suggests using disclosure numbers to make those references. And that's at paragraph 8.7. Importantly, for those of you who may practice in the insolvency sphere, paragraph 8.20 makes it clear that witness statements for applications should still be prepared in accordance with Civil Procedure Rule 32 and Practice Direction 32.
And then moving on, chapters 14 and 15 deal with applications. The guide now borrows from the commercial court and for the first time draws a distinction between what are known as ordinary and heavy applications. Dealing with ordinary applications first, paragraph 14.26 defines what an ordinary application is, and that is one which is listed for half a day or less with additional pre-reading time of no more than 90 minutes. Now, by way of example, this can include applications which involve oral argument, the delivery of judgment, and costs and consequentials. And the guide specifically mentions permission to appeal hearings as hearings which can fall within that ordinary application definition. And just lastly, on ordinary applications, in what's perhaps a clear signal of practice post-COVID, paragraph 14.28 provides that ordinary applications will be listed as remote hearings unless the court orders otherwise.
Turning to heavy applications and urgent applications. Heavy applications are those greater than 2.5 hours or which have pre-reading of more than 90 minutes. The guide emphasizes in paragraphs 14.44 through to 58 that they require serious cooperation between the parties. Indeed, the guide proposes that there is a longer time given for evidence timetables for defences and reply evidence, doubling up to 28 days for defence evidence and 14 days for reply evidence, and sets a upper limit of 25 pages for skeleton arguments, pending any permission to go longer. In terms of bundles, the guide expects those to be lodged 2 clear days before the hearing of the application, and with an electronic bundle in all cases. In relation to urgent applications, these are dealt with at paragraph 15.8 onwards. The default position is that they follow the heavy applications format unless the court orders otherwise, and that's at paragraph 15.10. All urgent applications should be made to a master other than those which can or should only be dealt with by a High Court judge, paragraph 15.11. And for the purposes of obtaining an urgent hearing, there is a certification process which must be followed, and that's set out in paragraph 15.12. And if it's not practicable to make an urgent application to a master, a letter explaining why needs to be filed with the application at court.
And just looking at skeletons in particular, the guide also contains some useful information about those. And building on what we've just mentioned and the distinction between ordinary and heavy applications, paragraph 14.43 states that a skeleton for ordinary applications should not exceed 15 pages, and that's including appendices and schedules. The guide does leave open the option for a party to file a longer skeleton, but it's important to note that the representative, the barrister or solicitor whose name appears at the bottom of that skeleton, must file a letter to explain why that length is necessary. Scarily, perhaps, the master or judge may reject this explanation and require the submission of a shorter skeleton, and/or, says the guide, cost sanctions may be imposed. And just again, in terms of heavy applications, as James previously mentioned, there is a 25-page limit, which can be exceeded by the parties, but the same threat of redrafting and/or costs consequences applies if the court rejects the representative's explanation.
Turning to trial skeleton arguments, the position's a little bit more fluid here, and is set out in paragraph 12.50 of the guide. They're to be filed not less than 2 clear days before the hearing, or, if earlier, 1 clear day before judicial pre-reading. The length is somewhat more forgiving, and they should not exceed 50 pages in length, save in exceptional circumstances. The guide notes that they are expressly not to be advanced closing arguments and are skeletons. Further guidance is contained in Appendix Y of the guide regarding the content of skeleton arguments and their delivery and filing at court.
And 9 out of 10, or 9 points out of 10, Appendix X covers the preparation of bundles. And the first point made by the guide in that appendix is that in all matters save for trials, only an electronic bundle should be filed unless the court requests otherwise. For trials, the requirement remains that identical soft and hard copy bundles should be filed. Now, the appendix is incredibly prescriptive as to the contents of bundles, the order of documents, and the formatting of the bundle itself, as well as its constituent documents. I would heartily recommend that all practitioners look to paragraphs 11 to 14 of that appendix, with a view to making life as easy as possible for both the court and your barrister.
And the final point that you should all bear in mind is Appendix Z, which deals with remote hearings. Following the pandemic and the forced nature of having to go into remote hearings, they are here to stay, particularly in relation to ordinary applications. But helpfully, what the guide contains now is an 8-page protocol at Appendix Z on how to conduct remote and hybrid hearings. It covers points on which the parties should cooperate over, points regarding attendance, conduct, including etiquette, not least in relation to who has the cameras on and microphones off, and issues regarding witnesses, and importantly, those witnesses where they are giving evidence abroad, and also expert evidence. So it's very important for all litigators dealing in the Chancery Division to familiarise themselves with this protocol to ensure that any remote hearings run without any hiccups. So there you have it, a whistle-stop tour of some of the key things in the new Chancery Guide litigators should be aware of. Remember, compliance with the guide should help you to avoid stumbling blocks as your case moves through the Chancery Division and is before judges or masters. Thank you for listening. It's goodbye from Dan, and it's goodbye from myself.